So the case of Parahi and Parmalat Australia Limited involved an employee that was terminated due to a medical condition and them not being able to fulfil the inherent requirements of the role. They brought an unfair dismissal case, and ultimately it was found that they were not unfairly terminated. So in this case, the employee was a cool room operator and required to utilise a forklift to carry out his duties. He was stood down on pay because he was overweight and could not operate the forklift, which had a weight restriction for a driver. He was subsequently sent on a medical assessment, and it was confirmed that he was unfit to drive the forklift due to being overweight and beyond the weight restrictions that the forklift allowed, and also due to having severe sleep apnea that he shouldn't be operating heavy machinery. There was some communication between the employee and employer about this, including the employee providing his own medical certificates that stated that he was fit to carry out forklift work. However, this medical certificate didn't have any regard to the weight restrictions. Further, there was a second medical assessment that he was sent to because the matter went on for so long and he was placed onto unpaid leave. This second assessment found that he had in fact put on more weight and therefore was still unfit to carry out the duties. Ultimately, he was terminated because he couldn't carry out the inherent requirements of the role. And in this case, it was found out afterwards that he had undergone surgery and lost some weight. However, that was never disclosed to the employer that he was going to undergo surgery before he was terminated.
It's one of those difficult decisions when an employer is faced with a clear medical issue and has to decide how to approach it for the safety of the employee and the rest of the workforce. I think one of the things that the employee did correctly in this very difficult situation is that they relied on medical information, and they sought proper medical information rather than their own assumptions about what could or could not be done, and that's the absolute key in relation to this type of matter, that you actually are not assuming that you know what's going on, you're actually getting information from the doctors, which is what they did. I also think one of the key issues in this matter, which we do see a lot in practice, is the treating doctor, and quite understandably, will often provide conflicting information. This person's fit for work, etc. And it's very understandable because that doctor wants to get the person back to work. Often, and you see this in back injury cases, mental health cases, many types of matters, they feel it's best for their patient to return to work. Unfortunately, however, the employer has an obligation. Unfortunately, the employer can't always rely on that because they also have an obligation to ensure the health and safety of that employee and others at work. And often you will have to go to an independent doctor to get an assessment of the situation.
And often the treating doctor doesn't have a full understanding of what the duties are, whether that's because the employee has been selective in telling them what they do, or has just failed to understand that maybe telling someone that they're a forklift driver doesn't translate to thinking about weight restrictions, etc.
Yep. And often, a doctor that is dealing with occupational matters will have a better idea than the treating doctor.
Yeah. And also a big part of this case was that the employee tried to claim that after his employment had ended, he was undertaking medical treatment to lose weight, and in fact had lost weight at the time of the hearing. But the Fair Work Commission found that the employer didn't know about that at the time, and therefore that was a relevant consideration. They had to go on what was in front of them at the time, and at the time it was that he was unfit to work.
And if in fact the Fair Work Commission had found on another basis that the termination of employment was unfair, that weight loss may have been relevant to reinstatement, but you have to consider fairness of the termination at the date of the termination.